Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about post-offence conduct. Cases that should have gone to the Supreme Court of Canada, but didn't. Mark Staples was charged in the murder of his parents. A couple days after they went missing, but before they were discovered to have been murdered, Mr. Staples was observed crying, very emotional, and perspirating significantly. Witnesses at trial testified that it wasn't usual for him to be sweating that much, and that the sweat was something that was out of character for him. This evidence was then relied on by the Crown as evidence of post-offence conduct and consciousness of guilt in relation to his parents' disappearance and ultimately their murder. Mr. Staples challenged this decision on the basis of the fact that this was an unfair use of emotional information. And this case raises a very important issue for the Supreme Court of Canada, which is one that has been very trending in Canadian law lately, which is what type of common sense conclusions can be drawn from ordinary human behavior. What is ordinary human behavior? And how do triers of fact, juries or judges, assess the way that somebody behaves, somebody's physical or emotional reaction to a stressful situation? Even if sweating is out of character for somebody, is sweating out of character for somebody whose parents have gone missing? Or is it only consistent with somebody who is sweating because they know that they're guilty and they've killed their parents and hidden the bodies? This was the issue in the case, and the Supreme Court of Canada had the opportunity to really clarify the law related to common sense inferences about human behavior, which it really hasn't done in a significant period of time. And because common sense inferences about human behavior are used not just by judges, but also juries, in all sorts of criminal cases and in civil cases and in testing credibility of witnesses, the Supreme Court of Canada had an opportunity to clarify an important and evolving issue in the law at a point in time before it gets out of control and before we have all sorts of different inconsistent judges rendering inconsistent judgments across the country, at which point they'll need to wade in and sort out the mess. This was an opportunity for the Supreme Court of Canada to stop the mess before it began, and unfortunately they missed that chance. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.